Constitution. The ANC contends that if its application is not heard, it will be denied substantial redress in due course because it is impugning MK's registration on the basis that it is unlawful. If the application is not heard, an unlawfully registered political party will, to the prejudice of voters, participate in the national and provincial elections scheduled for 29 May 2024, thus denying it substantive redress in due course. We find that there's no merit in this contention. For the reasons I've already stated, the ANC is not only barred from bringing this application, but also non-suited by operation of law. It is therefore not entitled to substantive redress in due course. Therefore, in terms of Rule 6, read with Rule 10, it does not meet the requirements for condonation. The ANC is facing an even greater hurdle. It impugns the 7 September 2023 decision in the wrong forum. The impugned decision was lawfully made. All these factors do not support the exercise of this court's discretion to overlook the delay in the interests of justice. We set out reasons for these findings below. I now deal with the jurisdiction points in limine. The ANC seeks to invoke this court's review jurisdiction. The respondents contend that this court lacks jurisdiction to review the impugned decision as it is not a decision of the Electoral Commission. When interpreted with reference to the language used, the context and purpose of the Electoral Commission Act, the interpretation in Section 20, subsection 1, which the ANC is contending for, is unsustainable as it will undermine the dispute resolution scheme created in the Electoral Act. As already held, when it failed to object to MK's application for registration, the ANC became non-suited. The Electoral Commission Act does not make provision for an aggrieved third party to impugn a political party registration after the period provided for in Section 15, subsection 4 big A notice has expired, or by way of these proceedings, as the ANC seeks to do. Section 16(2)(b) only affords parties who objected the right to impugn the DCEO's decision to register a political party. The ANC could not successfully use the internal dispute resolution mechanisms provided for in the Electoral Commission Act when it appealed the impugned decision to the Electoral Commission. The appeal was dismissed because the ANC is non-suited in terms of Section 16(2)(b) from impugning that decision. This application is also unsustainable because the ANC can only impugn the Electoral Commission's 24th November 2024 decision invoking the Electoral Court's jurisdiction in terms of Section 20, subsection 1. The ANC has preempted that decision. Notably, when it appealed the impugned decision to the Electoral Commission, it did not raise the ground of review it raises in these proceedings. The ANC blames the DCO for non-suiting it when he considered MK's supplemented application and not a fresh one as stated in his 4th August 2023 letter. It further contends that had the DCO insisted on a new application for registration being filed by MK, the latter would have had to publish a new Section 15, subsection 4 big A notice, thus affording it an opportunity to become an interested party by objecting to MK's application for registration. Hence, it contends that the DCO's decision falls to be reviewed and set aside as it was unlawfully made. The predicament that the ANC finds itself in does not justify a wide interpretation to Section 20, subsection 1. Such an interpretation would undermine the statutory dispute resolution mechanism provided for in the Electoral Act. It also does not promote the realization of the rights in Section 19 of the Constitution. We therefore find that the Electoral Court lacks jurisdiction to review the DCO's 7 September 2023 decision. It only has jurisdiction to review the Electoral Commission's 24th November 2023 decision, which the ANC has effectively preempted, as it is not reviewing it. For these reasons, the respondent's jurisdiction, point in limine, stands to succeed. I will now hand over to my brother to deal with the merits.
Yes. Under the heading, the merits, the judgment provides as follows, and this is just a truncated version of what the judgment says. The only issue to be considered by this court is whether the DCEO acted lawfully and in compliance with the peremptory procedural requirements for the registration of a political party when he registered MK. Crystallized further, the question to be decided by this court is whether the DCEO, in having had regard to a so-called, quote, supplemented, end quote, application by MK, when he registered MK as a political party, acted within the four corners of Chapter 4 and Section 15 and 16 of the Electoral Commission Act, read with its regulations. Contrary to the ANC's contention, not much turns on the interpretation of the DCEO's letter of 4 August 2023. The ANC's case is that the provisions of Section 15(1) were not complied with by the DCEO when he made the impugned decision. This, the ANC contends, was due to the fact that the application which had been filed by MK and in respect of which there had been publication in terms of Section 15(4)(a) had been vitiated and in effect rendered pro non scripto by the DCEO's rejection letter of 4 August 2023, in which he advised MK as follows, and I quote, "Please take note that the application for the registration of the above-mentioned party has been rejected because the signatures of supporters on the deed of foundation showed patterns of discrepancies which indicate that the signatures were made by a person or persons other than the voter," end quote. The ANC argues that MK failed to submit a, quote, fresh, end quote, application. It also failed to publish a fresh Section 15(4)(a) notice in the Government Gazette, informing the public that it seeks registration. Instead, it supplemented its initial rejected application, even though there is no provision in the Electoral Commission Act for supplementation of an application that has been decided upon and rejected. Pursuant to such supplementation, the CEO unlawfully registered MK on 7 September 2023. The law applicable to the registration of political parties, in particular Section 15(1) of the Electoral Commission Act and its interpretation, so the argument on behalf of the ANC is concluded, does not permit an application for registration to be supplemented. Its interpretation of the said section, according to the ANC, is supported by the 4 August 2023 letter, which clearly and unambiguously states that MK's application was rejected and that it is not, quote, debarred, end quote, from submitting a, quote, fresh application complying with all the requirements, end quote. Whether these submissions on behalf of the ANC are sustainable depends on a proper interpretation of Section 15, read with the regulations and Annexure 1 thereto. It is so, as was held by the Constitutional Court, Effectual Life Assurance Limited and others, that the legislature and the executive in every sphere are constrained by the principle that they may exercise no power and perform no function beyond that conferred upon them by law. The simple point being that in terms of the principle of legality, the CEO could not register a political party in a way, and in terms of a procedure, that he is not empowered to do by the Electoral Commission Act. We find that the requirements for the registration of MK in terms of Section 15 of the Electoral Commission Act, read with the regulations and the annexures thereto, properly interpreted, were met. The important point about Section 15.1 is that in peremptory terms it envisaged that the CEO, quote, shall, end quote, register an applicant as a political party upon application, quote, upon application by that party in the, quote, prescribed manner and form, end quote. We interpret this clause, quote, upon application, end quote, to require the CEO to have before him the application, quote, in the prescribed manner and form, end quote, when he registered the applicant as a political party. It matters not on the construction of the section that the construction of the section, the regulation, and Annexure 1 thereto, how the application came before him, or whether it came before him in one go or in phases, or, for that matter, in the proverbial, quote, drips and drabs, end quote. Contrary to the ANC's submissions, the absence of a reference to Section 15.1 to, quote, supplementing, end quote, of the application does not detract from the fact that on a plain reading of the provision, the words, the grammar, and the syntax of the section lend itself to an interpretation that as long as the application in the prescribed manner and form is before the CEO, he should register the political party. The ANC's contention that because the section makes no reference to supplementation, an application cannot be supplemented holds no water. It is an artificial approach. It implies that contrary to the substantive approach to the consideration for an application for registration, as implied from the reasons for which the CEO may decline to register a political party, which are set out in Section 16.1, the CEO should refuse to register a political party for elementary administrative details which the Act and the regulations did not deem necessary to prescribe. Nowhere in Section 15 of the regulation or the regulations is the manner in which the application is to be submitted prescribed. Importantly, the section does not require an applicant to comply fully at the first go. As regards context, there was no need for an applicant, after an application for registration is rejected by the Electoral Commission, to commence the whole process afresh. 14 days had passed since the corrected Section 15.4a notice was published on 30 June 2023, and the ANC had not registered an objection. Therefore, the DCEO was not prohibited from registering MK in terms of Section 61. Moreover, the Electoral Commission has demonstrated that there were other political parties which also supplemented their applications after initial rejections, whereafter their applications for registrations were approved. This translates into a contextual interpretation that favors the respondent's case. As for purpose, at the heart of Section 15 are the political rights enshrined in Section 19 of the Constitution. With that purpose in mind, Section 15 is aimed at ensuring that every citizen can form and register a political party. That therefore means that the said section should be interpreted in a way which facilitates the formation and registration of a political party as against hamstringing it. That purpose is attained by an interpretation contended for by the respondents in casu. For all of these reasons, it is iterated that the DCEO in registering MK complied with the requirements of Section 15 of the Electoral Commission Act, read with section 16.1, the regulations and Annexure 1 thereto. We therefore find that there is nothing unlawful about the registration of MK by the DCEO on 7 September 2023. As regards costs, in line with the principle in Bywatch, costs are customarily not awarded in this court. We have not been persuaded to depart from this custom.
The order reads as follows. In the result, the following order is made. The application is dismissed with no order as to cost. As to costs. We hand down judgment. Gladys? Gladys?
In the media summary.
Ngaleyo ndlela yamaqabane ngifuna ukunibonga ngesupport eniyenzile nokubekezela ke benithukuluza ngeincwadi ebeyikhishwa kuma social media bekusebewinile kanjani kodwa anizange nomsusa umsindo ngoba bebenza lezi incwadi ngoba benzela ukuthi kube nomsindo ebese ama-elections ahle asingabavumile ngoba bengasibeka umuntu esweni asibekezele nje so babona ngale kwamhla ka-29 sesibakhiphe ngevoti bese bazi ukuthi hayi sekufanele bahambe bolusa inkomo ngoba phela ngeke abanye bohamba bokuthatha iy'ngane emakhaya amandla viva Zuma viva thatha msholozi thatha sihole msholozi sihole angiyeze nanguthi G
Viva Titi! Viva! Amandla! Pata UMkhonto pata! Kwaza UMkhonto kwaza! Kwaza UMkhonto! Comrades, we want to thank you. Sifuna ukumbonga. Amandla, comrades. Sifuna ukumbonga, comrades. It hasn't been an easy journey. Bahlezi basilungisa. And we know that. Nakusasa siseDurban sisayolwa. But siya eThekwini with high confidence, comrades. Ngoba ayikho into esiyifisha. Sithi comrades asiyene eDurban. Siyolwa lento. But okubalekile to note, comrades, uthi commander la. Bahlulekile ukuphathizwe labantu. But what you need to realize is the attitude yabo to jumping and quickly responding to ukuvimba UMkhonto through the courts. I so wish the same attitude could have been deployed ukuzama the plight of the African child. Clearly, last abantu where ama objectives wabo and our priorities wabo are self-centered. But we want to say, comrades, ukuthi asiconfineni thina ifight to the ballot box. Yes. Irrespective of what happens, comrades. Let's do that, comrades. Sien phambili siyogwaza on May the 29th. Amandla! Zonikeza ngapha uComrade Ntontoni.
Ayibuye. Comrade nakanjani izobuya. It is UMkhonto Wesizwe wafonyelwa lento ezinjengalezi. UMkhonto Wesizwe mawulanda i-background yawo ufonywa ama-organization ayi-5 bewabizwa ngokuthi i-Alliance. It's ANC, South African Communist Party, Indian Congress, SACTU, and the Colored Congress. UMkhonto Wesizwe uba wokuqala ukuthi ube non-racial. Responda to a situation whereby amabhunu besewabhene all organizations of black people. Namhlanje UMkhonto Wesizwe uresponda ku situation whereby the ANC is being captured. Ikapturwa abelungu abantu abayocela imali ebantwini abagqilaza umuntu omnyama babuye bazozenza better badefine i-freedom yethu as if besingazi ukuthi silwela. It is today la sizokhuluma ukuthi lesa silwela siyayazi, and they will never stop to fight for it. Sizoyilwela size siyithole inkululeko. We are not just singing the song ukuthi sizoyilwela inkululeko size siyifumane. Sizoyithola and sizoyidefine ukuthi what is freedom. I-freedom ayiqali phezulu ize phansi. I-freedom iqala phansi iya phezulu. Mawubona lobuholi obukhona be-MK obesikhashana, ubuholi ekuthiwa yithunywa. Mawuhlezi in a position of MK uyisithunywa. That's why we stress to say those who will go into government will never lead the party, because they must come back and account into the party and make sure ukuthi the resolution of the party are being implemented. And ama resolution we party mele abuye ebantwini, emalokishini, emikhukhwini endaweni esihlala kuzo. We must address a situation ebahluleke ukusi-address. A problem esibenayo kuleli zwe leli, sibe problem where people they think money is power. Now we will redirect that attitude from ebantwaneni bethu bazothi bakhula from 29 abantwana. They will understand ukuthi power is respect. If power is to respect the person next to you, it is a law of nature given by God. Ukuthi hlonipha umakhelwane wakho njengoba uzithanda nawe. Hlonipha uyihlo nonyoko, but on that one hlonipha uyihlo nonyoko in a reward. It ukuze insuku zakho zande emhlabeni. So we'll make sure ukuthi each and every South African uphila lempilo ezoba ne-reward. Uphila lempilo ezokwazi ukuthi ahloniphe abantu abathole ngaphambili ngoba indlela ibuzwa kwabaphambili. We'll make sure ukuthi abantwana bethu bakhula bazi ubuntu, bangazi lento esizifundiswayo namhlanje nale mithetho eyabekwa emakhoti esimoshele ilizwe. Imithetho eminingi yabo AfriForum esimoshele ilizwe iyophela nge-29. Forward to that majority, forward. Forward to that majority, forward. Kijima volunteer kijima. Kijima volunteer kijima. Yautata umbuso yautata. Thank you, comrade.
Bajabula abalandeli be-MK emva kwempi ebiphakathi kwe-ANC ne-MK. I-ANC ebizama ukuthi MK direjiste e-IEC emva kwey'nsolo zokuthi bathathe igama lomkhonto wesizwe ekuyigama le-ANC kanye nelogo ye-ANC kuyaqhutshekwa kusasa e-KZN kuyolelwa ilogo.